Welcome to episode 3 of the Farm Life Podcast, brought to you by the Kings County Farm Bureau. I'm your host, Dusty Ferentz, and Executive Director of the Farm Bureau. And with me today is David Kahn, partner at Soares in Conway and Hanford, and Kings County Farm Bureau Director. David, welcome to the show. Why don't you start by telling us a little bit about yourself and your role in Sigma to date?
Sure, I'm happy to be here. Like you said, I'm David Kahn, Soares and Conway law firm. Our firm is a general practice firm, but specializing or doing quite a bit of agricultural and water law, both in our Hanford and Sacramento offices. In Sacramento, we also do some government advocacy, so we like to look at issues both from a legal and a political standpoint. I do quite a bit of water law representing irrigation and water districts, landowners, and several GSAs throughout the San Joaquin Valley.
That's great. You've been involved every step of the way in our challenge of the State Water Resources Control Board, and your background and expertise can probably help us all understand the preliminary injunction that the judge just ruled in our favor on. Can you talk to us about that a little bit?
Sure. So the process is the Farm Bureau, in this case, filed a complaint and immediately sought a temporary restraining order and a preliminary injunction. The temporary restraining order is the first step. The court issues those on a ex parte basis, meaning on a fast basis, and then the parties get to brief their positions, and then the court decides whether to issue a preliminary injunction. What the injunction does is it restrains one party from doing something that they were seeking to do. And again, in this case, the court found in the Farm Bureau's favor to restrain the State Water Resource Control Board from implementing their probation and instituting fees and metering requirements and reporting requirements. And that restraint will stay in place pending the outcome of the trial. So that'll be in place until some date in the future after the court has heard the case on its merits.
Yeah, and right now we don't know when that date is likely to be. Talking with our attorney, it could be quite some time before this is all wrapped up and said and done.
Yeah, as I understand it, you have a case management conference, which is the conference where the court and the parties schedule the process, and your next case management conference is in January. At that time, probably a trial date will be set, but that could be a year or longer in the future.
Now, we had a case management conference last week, Friday, September 13th, and we have another one scheduled in January. Is there a chance that we don't set a trial date in January and we have to come back for a third case management conference?
Yes, there's always a chance of that. The court, for any number of reasons, or the parties could request a further CMC just because there's some procedural issues that need to be worked out before the parties are ready to go ahead and set those final dates.
Okay, perfect. So we might not know even in early January when we're back in court.
That's correct. Yeah, these processes take quite a while because of that.
For me, it's been really interesting to watch. We get these dates calendared, and it's been really interesting with my lack of experience to see how things change and what affects the court's decisions and what doesn't, and how calendars happen. It gets really exciting for 2 days of the month, and then there's kind of a long, drawn out, really quiet period. And I don't know if everybody understands that. I sure didn't going into this.
Yeah, that's right. And the courts are so backed up these days, especially Kings County, that they are often setting 3 or 4 trials on the same date, hoping that their calendars shake out. They often don't, so you might even get a trial date, and as you get closer to trial, the court realizes they still have 3 trials set on the same day, and they start pushing them out even further.
They got to push them back. All right. So let's go back and talk about the preliminary injunction some more. That ruling, that document was 33 pages long. And if I read it correctly, there were 4 causes of action out of the 8 that we originally filed that the judge ruled on.
Yeah, really, there's 4 reasons that the court found that the state should not be able to proceed in implementing probation. And so they gave an exhaustive list and reasoning behind that. To break it down, there were 4 main reasons that they found that it's more harm to the farmers then it is beneficial to the state to implement probation now. Those 4 reasons were, one was based on the good actor determination. The court found that the state did not adequately consider the good actor determination. That was a determination in statute and in regulation that allowed the state to carve out portions of a subbasin if a portion looked like they were, quote unquote, a good actor. They were going to be sustainable as the law requires or wants them to be. In this case, the court said that the state didn't consider that because this subbasin only has one plan, one GSP, ground sustainability plan, that there couldn't be a good actor essentially, and that doesn't comply with the law. So the court found that the Farm Bureau is likely to succeed on the merits on that particular issue. They also found that the state did not give adequate notice to all of the landowners that were going to be impacted by the probation. They went into a lengthy discussion of what the state could have done and failed to do. They also, this gets a little bit more into the weeds, but they found that the state had been doing underground regulations, as they call it, and so that is that there's a process and procedure to adopt and implement regulations. There was a whole host of examples where, in this case, they didn't. They came up with regulations on their own, and it didn't go through this process that the law requires.
The Administrative Procedures Act, is that right?
That's right. The APA. The state did not follow that on a whole host of what the court found to be actually regulations, so underground regulations, they call it. And then finally, the court just found that the state exceeded its authority. It didn't have the authority to do this process as they have done it. And so for those 4 reasons, again, the court found that we're likely, the Farm Bureau, is likely to succeed on the merits in its challenge of those 4 items, and therefore everything should be stayed until there's a trial in the case.
Yeah, that's great. Let's talk about trial in this situation a little bit. What does trial actually look like?
So this wouldn't be a jury trial. It'll be it won't be like you see on TV, the exciting stuff with the lawyers arguing to the jury and trying to make an emotional point. This is going to be a law-based trial, really, whether the state followed the law or not. And so it's not going to be the exciting thing you want to go sit in the courtroom and listen to, maybe, but it will be interesting nonetheless.
It's been interesting so far, that's for sure. We're not even to the good part yet.
Yeah, and one thing I wanted to, maybe you were going to get to this, but go back. What does the preliminary injunction mean to the grower?
Yeah.
And so, if I didn't mention already, what it means is the fees, the metering regulations, and the reporting requirements are all stayed. The farmer doesn't have to do any of those now. So this was a big help to the growers.
Huge help. It at least got them through, at the very least, 1 irrigation season without any fees. And understanding how long it takes to get a case like this heard, it might have gotten through 2 irrigation seasons.
That's right. Which also buys the GSA's time to improve their plans or get them to a spot where they can be approved by the state board and DWR. Yeah,
and with all the changes locally, with all the leadership changes locally for GSAs, an extended period of time to try and figure this out, hopefully we get there, right? That's what this case is really all about.
That's right, and actually the court commented on this in the preliminary injunction order that the Farm Bureau had already asked for more time. Just give us more time. At that time we were asking for 3 to 6 months. Mm-hmm. And the state board didn't give that time, and so the court, in a rather scathing way, let the state know that was a reasonable request, and we're right in the middle of irrigation season, and there was no need to fast track this at this point. So now we've even bought more time than that.
That's right. Yeah. That's right. Hopefully our growers recognize that.
Yes, I hope so.
So is it is it fair to say that the preliminary injunction stops everything that was contained in the resolution that the state board adopted when placing us on probation? More pointedly, what I'm asking is, does this action by the judge prevent the state water board from implementing an interim groundwater sustainability plan next April?
Uh, yes, it does. The state board everything's on hold until the trial, because that act of the state implementing its own plan was part of the probation, and again, that's in state.
Yeah, that's great. That's a little bit different than the initial ruling with the TRO, which was narrow in scope and focused just on fees and reporting. So I think it's important for people to understand this is a broader, more impactful action taken by the court as we're preparing for trial.
Yes, that's correct.
Yeah, that's good news. So what does it look like once we get to trial? And all signs right now are leading towards the judge ruling in favor of Kings County Farm Bureau. What does it look like moving forward from a trial date?
Yeah, so it's certainly the court could change its mind, but all signs are pointing now that on the merits of the case, so far what the judge has seen, the Farm Bureau and the other grower plaintiffs are going to be successful. And so what that would mean is that this probation would have been ineffective. The process would start again. There would be noticing procedures. There would be this whole process would go again, with the state board having to have corrected all the mistakes that they made the first time around, which could be, in the case of the underground regulations, for example, that could be a multi-year process, because now they have to go adopt regulations that they want to implement through the APA, and that's again another lengthy process. So really, this could extend this out for several years, and could impact other subbasins in that same way. Not, the underground regulation isn't something that has been corrected or could be corrected as it relates to the next subbasins that go through this process.
Right. So just to be clear, you mentioned a minute ago the process after the trial. So what you're suggesting is that the State Water Resources Control Board could hold another probationary hearing and consider whether or not to place the Tulare Lake Subbasin on probation in the future. But in order to do that, they would have to correct everything that has been called out in our case against
That's
them
right.
now.
They would be subject to the same challenges, some of which, again, would be easy to fix, the noticing issue. They just have to be more precise in their noticing and do that correctly. But the underground regulation, not so much. That could take quite a while.
That's a much bigger process.
Yes.
As we record this today, the Tule Subbasin over in Tulare County is before the State Water Board for a probationary hearing. Have you been able to listen to that at all today?
I have not. I have been involved in that subbasin and have followed their process very closely, but I have not had a chance today to listen in on that.
Yeah, the state's website has not allowed me on except for first thing this morning, and I got disconnected and haven't made it back on either.
Oh, I hadn't heard.
Seems like there's a lot of people paying attention.
Yes. Yeah, I bet there is. And a lot of people I know in the Tule and Kauai subbasins are watching very closely what happens here in Tulare Lake, because for all these reasons, what are their options should the probationary hearing not go their way?
Yeah, and our office, to that point, is getting a lot of calls from different groups or agencies in subbasins that have plans that are already adopted. As part of SGMA, GSAs have to be reviewed by the Department of Water Resources every 5 years, and they're at risk of being placed on probation at those check-ins. So even those people that are ahead of the game and implementing plans are concerned they might end up on probation in the future, and seem to be watching what's going on down here very closely.
Yeah, I'm sure. And what's interesting about this whole case is that it's a first of its kind as it relates. SGMA's a relatively new law, or newly implemented. We're the first ones to challenge it in this way. And so everyone's looking for the path forward should they find themselves in our same situation.
Yeah, it's been really interesting to see that. The draft staff report from the State Water Resources Control Board I haven't read every detail yet, but it seems to be pretty different than the staff report that was written for the Tulare Lake Subbasin. So much so that there were a couple of what are almost good actor clauses, carve-outs in the Tule Subbasin. There's 2 irrigation districts that the staff is suggesting do not have to pay registration fees or pumping fees. So it's interesting to see, we'd like to take credit for that. I don't know if we'd ever know, but it's interesting to see how these things progress.
That's right. And I had heard, although I haven't verified, but I think there were changes to the staff report in the Tule as recent as within the last week. And so I can't help but think that that's because of the activities going on over here in Tulare Lake.
That's interesting. I didn't realize that. I hadn't heard that about changes to that report so soon.
Yeah, that's what I had heard. So
could be.
Anyway,
yeah,
it's interesting. Everyone's watching, that's for sure.
Here's hoping.
Yes.
All right. So what else? What are we missing on this effort, or where we're at today, moving forward? What else do we need to know about?
Well, just that the Farm Bureau should be applauded. That's for sure. This was a risk. It comes at a significant cost. Again, it's somewhat of a novel process we're going through. The process has been done before, of course, but not on this law, and so, or on procedures that the state board implemented, and so the Farm Bureau took a risk and has shown to work out for them. So it should be applauded.
So far, so good. This is good for everybody. This is bigger than Kings County. This is definitely bigger than Kings County Farm Bureau. This really should make an impact for all of California and all of California agriculture. Kings County is not the only county in the state that's reliant on agriculture for the base of their economy. It just so happens that we got to go first. Good, bad, or indifferent, right or wrong, here we are. And for Kings County and other counties, I'm sure, agriculture is directly responsible for 1 in 4 jobs in the job market, and is the major contributor to property taxes, which means the major contributor to first responders' salaries, county and city services. So really, this is bigger than the farming community. This is bigger than Farm Bureau. We're fighting now for Kings County as a whole, and everything we've done so far is good for everybody, and we appreciate the support we've gotten so far.
Yeah, I absolutely agree with all of that. Recently agriculture's faced a whole host of regulations that have added costs and difficulty to their daily life, and this was just another one, and so we bought some time, if nothing else, to try and deal with it.
That's right. Well, that sounds like a good note to end this conversation on, unless you've got anything else.
I don't think so. Just thank you for inviting me.
Well, thanks for being on today. And for our listeners out there, you heard from David today. This is quite a journey, and you guys can be a part of it. We need to raise money for the Sigma Defense Fund. So far, contributors have contributed enough to pay our legal bills, but we're a long ways from finished here. Our early estimates, we thought this was going to cost $400,000. We've invested $225,000 to date, and it's really looking like we're going to spend $500,000 instead of $400,000. So if you're interested in being a part of this journey, we invite you to check out kcfb.org and look for the Sigma Defense Fund page, and consider making a contribution and helping us fight for all of California and California agriculture.